Verðið öll hjartalega velkomin í þennan sögufræga sal, sjálfstæðissalinn eins og hann heitir nú. Ég held ég fari rétt með það, þó að sjálfsögðu ég muni það ekki af eigin reynslu að það hafi einmitt verið hér í þessum sal sem Bjarni Benediktsson heitinn flutti sína sögulegu ræðu að Íslendingar skyldu þrátt fyrir heimsstyrjöldina nýta sér rétt sambandslagana til að stofna lýðveldi. Það var áhrifaríkasta ræðan sem lagði efnislegan og lagalegan grundvöll að því að þrátt fyrir heimsstyrjöldina og langvarandi tengsl Íslands og Danmerkur, þá hefðum við fullan rétt til þess að stofna lýðveldi á Þingvöllum. Ég nefni þetta nú bara hérna í upphafi svo að þeir sem kannski yngri eru og ekki sérfræðingar í sögu Sjálfstæðisflokksins átti sig á hinu sögulega mikilvægi þessa salar sem auðvitað hérna líka við Austurvöll sem hefur verið samkomustaður Íslendinga frá lýðveldisstofnun til þess að fagna þeim áfanga. Það eru 3 vikur til kjördags og eins og góð kona sagði á Sprengisandi í gærmorgun að það hefur einhvern veginn þannig verið haldið á þessu máli með tímasetningu og öðru að aðalumræðan hefur farið fram eins og hún sagði í kommentakerfunum á Facebook. Það er auðvitað ekki mönnum bjóðandi fyrir einhverja mikilvægustu ákvörðun sem við höfum tekið á þessari öld og jafnvel frá lýðveldisstofnun að umræðan sé bara í kommentakerfunum á Facebook og þau séu ágætt til síns brúks. Og eins og við þekkjum öll að þá hefur farið mikið fyrir umræðu verðlag á kaffibollum og pitsusneiðum og kjúklingabringum og öðru slíku sem út af fyrir sér ágætt, þeir sem hafa áhuga á pitsusneiðum geta rætt það alveg fram og aftur. En það hefur eiginlega alveg gleymst í þessari umræðu að Evrópusambandið er einhvað umfangsmesta og ítarlegasta og þraulskipulagasta valdakerfi sem búið hefur verið til í okkar heimshluta frá síðari heimsstyrjöldinni og grunnvefurinn í þeim mikla strúktúr er það réttarkerfi og svo réttarhugsun sem gengur venjulega undir nafninu Evrópuréttur og felur í sér víðtæka lýsingu á hlutverki einstakra valdastofnana, samspili kommissjónarinnar við einstök lönd og hvaða áhrifasvæði þingið og kommissjónin og Evrópudómstóllinn hafa gagnvart aðildarríkjunum. Og eins og ég nefndi fyrir skömmu síðan, þá er það satt að segja nánast óskiljanlegt að fram að þessum degi hefur nánast ekkert verið rætt Lissabonsáttmálann í þessari umræðu. Bara ekki neitt. Og þegar ég nefna hann við fólk sem hefur verið í þessari umræðu vikum eða mánuðum síðan þá segja með Lissabonsáttmálann, byrju, hvað er það? Hvað er það? Sá grunnsamningur sem Evrópusambandið gerði skipan valdsins og ákvörðunartöku og rétt einstakra stofnana og tók gildi 2009. Og þó að margt megi segja hinn margrædda pakka, þá er það alveg ljóst að hvernig svo sem hann kann að líta út á endanum ef hann nokkur sinni birtist, þá verður Lissabonsáttmálinn í honum. Þá verður Maastricht-sáttmálinn í honum og þá verður Rómar-sáttmálinn í honum. Vegna þess að þessir 3 sáttmálar eru burðarásin í því sem að kann að verða í þessum pakka. Skilgreina sjálft gangvirki Evrópusambandsins og hvernig það getur tekið á nýjum vandamálum og þróast. Og þegar mönnum svo sagt það eða á það bent, eins og Stefán Már Stefánsson, prófessor emeritus í Evrópurétti, sagði í gær, að jafnvel þótt að samið væri einhverjar undanþágur varðandi fiskveiðistjórnina, þá gæti Evrópudómstóllinn ógilt þær með einföldum forúrskurði. Á grundvelli þess að Evrópudómstóllinn hefur samkvæmt þessari grunnskipan vald til þess að fella úr gildi samninga sem kommissjónin hefur gert við einstök ríki. Leiðangurinn sem þjóðin beðin að blessa felst í því að við göngum inn í grundvöll og valdakerfi háþróaðrar réttarhugsunar sem Evrópurétturinn, Evrópudómstóllinn, nýskipan kommissjónarinnar á grundvelli Lissabonsáttmálans og mismunandi vægi einstakra ríkja í ráðherraráðinu á grundvelli Lissabonsáttmálans fela í sér. Þetta kjarni málsins. Allt hitt bara aukatriði. Stefán Már Stefánsson, sá aldraði og virti prófessor emeritus, kannski mesti sérfræðingur sem við Íslandingar höfum átt í Evrópurétti, og það segir kannski dálítið akademíuna að hún hefur ekki endurnýjast á síðari árum og áratugum á þann hátt að hann enn háaldraður, fremsti sérfræðingur Íslands í Evrópurétti. Og hann sagði í gær: valda framsal ríkisvaldsins til Evrópusambandsins verður verulegt. Og hann áréttaði það með því að ítrekka á því væri engin vafi. Og ástæðan fyrir því að ég fór fram á þennan völl fyrst með ræðunni hér á þessu sviði var að mér var ekki sama lýðveldið, mér ekki sama árangurinn á sjálfstæðisbaráttunni, mér ekki sama það hvort að framtíðarkynslóðir Íslandinga fá í sínum höndum sama rétt til að móta sína framtíð eins og við höfum haft sem erum hérna í þessum sal. Og það í þessu ljósi að þjóðin ætlar eftir 3 vikur að ganga að kjörborðinu að beiðni ríkisstjórnarinnar og ráðherrana sem hafa sett þessar þjóðaratkvæðagreiðslu á dagskrá án þess að nokkur ráðherra hafi nokkru sinni í þessum aðdraganda minnst á Lissabonsáttmálann. Ekki einu orði. Að það fagnaðarefni að við skulum hér í dag í þessum sögufræga sal eiga kost á því að hlýða á þann mann sem nýtur einnar mestrar fræðilegrar virðingar í bæði akademískum og lögfræðilegum og stjórnsýslulegum heimi Evrópu fyrir fræðilega hæfni sína á sviði Evrópuréttar. Dr. Karl hefur verið prófessor við fjölmarga háskóla. Hann hefur skrifað 40 fræðibækur Evrópurétt. Hann var valinn til þess að vera forseti EFTA-dómstólsins og beitti sér þar með þeim hætti að, eins og ég hef áður sagt, að engin erlendur lögfræðingur hefur skipt meira máli í sögu Íslendinga heldur en hann. Þegar EFTA-dómstóllinn vísaði Bretum og Hollendingum og Evrópusambandinu á dyr og sagði: kæru vinir, þið eigið engan lagalegan rétt. Og hann hefur sjálfur sagt að sá grundvallar munur að hans dómi á eðli EFTA-dómstólsins og Evrópudómstólsins að það væri afar ólíklegt að slíkur úrskurður hefði fallið hjá Evrópudómstólnum. Vegna þess að réttarkerfið ekki bara lögfræðilegt fyrirbæri, það líka valdastrúktúr. Þess vegna vil ég þakka þeim sem höfðu frumkvæði og dug til þess að bjóða honum hingað. Ég sé að Ragnar situr hér á fremsta bekk, þakka honum fyrir það og félögum hans, fyrir að hafa beitt þátt fyrir það að þeir væru emeritus prófessorar stofnunum háskólans til þess að bjóða Dr. Karl Baudenbacher að koma hingað til okkar. Hann að gefa út bók á íslensku sem mér sagt að hafi komið út í dag eða komið út í þessari viku, þar sem að nánar má kynna sér málflutning hans og ég hvet alla til þess að eignast það rit, vegna þess að við eigum bara 3 vikur eftir til þess að geta loksins farið að átta okkur á því hvað felst í þessu mikla lagakerfi og þessu ríkisvaldsskipulagi sem Evrópusambandið Ég hef tekið eftir því að undanförnu það ekki margir sem átta sig á því að það hefur ekkert land gengið í Evrópusambandið síðan 2013. Ekki neitt. Við yrðum fyrsta landið í rúman áratug til þess að taka það upp í okkur sjálfum að hefja á ný þessa vegferð. Þannig að við þurfum að hafa alveg tæra og skýra mynd af því hvað felst í því húsi, hvernig það innréttað sem þjóðin beðin að segja já, við viljum að þú kannir það hvernig þetta hús lítur út, þó að þeir sem nota orðið könnun hafi ekki átt að sjá því að Evrópusambandið ræðir ekki við nokkurn mann nema þá sem að vilja koma inn og setja sig niður í einu af svefnherbergjunum sem hús Evrópusambandsins býr yfir. En kæru vinir, þakka ykkur fyrir að fjölmennast og hér í dag fylla þennan sal, þennan sögufræga sal og ég vil bjóða Karl Baudenbacher velkominn hérna á svið. Hann gjör svo vel. Hann þurfti nýlega að fara í hnéaðgerð, svo hann hefur kosið að sitja hér á sviðinu. Ég bið ykkur að fagna honum og góðu. Well, as you can see, people are very grateful that you have made the effort to come to Iceland, to allow us to share in your academic wisdom and your legal insights. And we indeed feel very privileged to have you here 3 weeks before the referendum takes place. I said in my remarks in Icelandic that in our modern history, I don't think there is any lawyer outside of Iceland who has played such a significant part in our history through your presidency of the EFTA Court and also throughout your distinguished legal career as professor with many distinguished universities and author of 40 books or so on European law. We are being asked, the nation, to say yes or no to a journey which has the aim of bringing us into the extensive legal and systematic framework which we call the European Union. And I think it's fair to say that many in our country lack extensive knowledge of how is this framework really constructed and what are the legal and democratic principles at stake. So with these words, I welcome you again. I've explained through your knee operation you prefer to sit on the stage. After your talk, you have graciously agreed to take take questions. We have microphones in different places in the hall, and you have to raise your hands and indicate whether you want to ask a question, and then state your name and position, and we will try to run this in the democratic, open spirit, which in my times at the university was the essence of academic life. So, Dr. Karl, please.
Thank you very much, Mr. President, for your kind words of introduction. Ladies and gentlemen, I'm very pleased to be back in Iceland. My wife, Doris, here sitting in the first row, has kindly accompanied me here. And this shows that Iceland can still attract distinguished visitors, even when they come in my company. I shall return to her contribution to my understanding in the IceSafe case later. I first came here almost 30 years ago for an EFTA event at La Perla, and during the 15 years of my presidency of the EFTA Court, I returned almost every year. I gave lectures at all 4 Icelandic universities. I visited courts and met politicians, officials, lawyers, academics, and students, always with the proper distance. Over these 3 decades, I have witnessed the extraordinary development of your country. But I also remember the financial crisis in very concrete terms. I was here in the fall of 2008. In the evenings, food shops placed cardboard boxes with bruised vegetables and fruit on the pavement, and well-dressed people quietly took pieces home. That memory has stayed with me. It is one reason why I do not think that institutional autonomy, public debt, and monetary flexibility are abstractions. Now, after leaving the EFTA Court, I had the honor for 2 years to advise your government. Now, in a sense, I find myself on the other side of the argument, but it's one of the great advantages of liberal democracy that we can argue strongly without breaking each other's heads, as far as I am concerned, at least. My argument proceeds in 8 steps. First, what does it mean to sit at the EU table? Then number 2, what about the geopolitical situation? Number 3, what about democracy deficits? Number 4, what about exemptions from European law? Then comes the value of the EFTA pillar. Then comes number 6, energy. Number 7, the question, is EU membership an attractive option? Is the EU in such a great shape that it is worthwhile to join? And my last point is very important. What is the real function of the referendum of the 29th of August of this year? So let me start with the issue of sitting at the table. The familiar seat at the table argument is too simple. The question is not whether Iceland would have a seat. The question is, at which table, under what conditions, and with what real influence? And what would Iceland have to give for this seat? Now, my answer is quite clear. Most importantly, decisions are taken by Paris and Berlin. The real important decisions are taken by the French and by the Germans. After Brexit, I was for 2 years engaged in important work in London, and I sometimes had the impression that the French and the Germans were not so unhappy that the Brits had left, because the Brits had the reputation of being troublemakers. Now, secondly, I may mention here Italian Prime Minister Giorgia Meloni. Italy is one of the big powers of the European Union, and she has sharply criticized the renomination of President von der Leyen for a second term as Commission President. And in Meloni's view, the deal was not the result of an open process, but a closed, I'm quoting her here, a closed-door agreement among the established power blocs. She said an oligarchy overriding the voters' message. And the Icelanders should think of this characterization when some armchair professors say, oh, we would have a vote and a seat at the table. Now, an interesting development has occurred in my home country, Switzerland. The Swiss government has, over 30 years ago, lodged asked for membership in the European Union. And in June 2023, the Swiss government has officially ruled out the goal of membership. And they said it's not helpful for 4 reasons. We would surrender a high degree of policy autonomy. Then decision-making would partially shift from Swiss to EU institutions. Third, direct democratic mechanisms would remain formally intact, but would have less substantive impact. And 4, participation rights gained through EU membership would not compensate for the resulting loss of national room for maneuver. I come to the second issue. That's the geopolitical situation. That's a very emotional argument in favor of EU accession. It is said there is uncertainty about the US. We have the Ukraine war and the Iran war, and there is pressure on the international order. And in this situation, it would be wise to join the European Union. I would say the following here. You see the picture here of Kaja Kallas, the foreign policy envoy of the European Commission. Iceland's hard security rests on NATO and on its US defense agreement and not on the European Union. European Union is not a military association. Accession would add political embedding but no protection, and the EU itself is depending on US capabilities. Kaja Kallas was invited to give the so-called Churchill lecture in Zurich in Switzerland earlier this year. And there she claimed that the European Union was the last defender of the rules-based international order. And this claim is untenable. The EU just has less power than the US and China, but where they have power, they don't stick to the rules at all. And I can tell you from my Swiss experience that the European Union is trying to force Switzerland to accept its own Court of Justice, the Court of Justice of the European Union, as the ultimate interpreter of bilateral treaties between Switzerland and the European Union. And already the Romans knew that nobody can be a judge in his or her own cause. Nemo iudex in causa sua. The European Union is trying to play the same game with the British. Now my question is, if the Germans or the French or the Italians would be in this situation, would they accept the court of the other side? Most probably not. I remind you of the golden rule, which is accepted in virtually every religion. Treat others as you would want to be treated yourself. And that's what the European Union is not doing here. I come to the third issue, the so-called democratic deficit. Everybody knows that the EEA has a democratic deficit because Iceland, as Norway and as Liechtenstein, adopts internal market law without a voting right. However, EU membership would only mean exchanging this democratic deficit for another, because in the European Union, responsibility would shift from Parliament. Parliamentarians should be aware of this, to the government and to the EU institutions. The EU's democratic deficit separates power from accountability. Decisions emerge through the Commission, the Council, committees, agencies and courts, and responsibilities are hard to locate while national parliaments lose control with no democratic substitute on EU level. My fourth point concerns exceptions. When I read what certain people say here in this country, I think they have the imagination that they can negotiate an exception for virtually every policy area where they would like to have such an exception. Now, it may be, if you look at Åland and the Danish opt-outs, it may be that you can negotiate a special arrangement here and there, but not in all policy areas. And usually such exceptions are given to existing member states and not to the newcomers. It would be very rare if Iceland would get such an exception for fisheries, for instance. You have here the Icelandic flag carried by a cart. I've made these slides myself. I'm very proud of this, Fisheries is central for Iceland. You know that much better than I do. A permanent solution is not legally excluded, but the closer it comes to the EEA model, the higher the hurdles. Accession means being subject to the common fishery policy, and that's a core of EU law. And there are other fishing nations in the European Union. My wife and I normally spend summertime on the Spanish coast, not this year, because this year Iceland had priority. But if you go there, they have basically depleted their fish grounds, and they would be quite happy to come up here and to catch the fish here. And you know that in 1615, some 32 Basque whalers, subjects of the Spanish crown, were killed in the West Fjords of this country. And the sheriff Ari Magnusson decreed that Basques and Spaniards could be killed on sight there. Now this law has been repealed. That means if they would come back, you couldn't kill them anymore. I come to the fifth point, the value of the EFTA pillar. And that value I have experienced myself. The EEA permits deep and legal participation with only partial political absorption. The EFTA states were able in 1992 to persuade the Court of Justice of the European Union to share its monopoly on interpretation of internal market law with the EFTA Court. The EFTA Court is not the lower court. ECJ is not the court above the EFTA Court. This was a revolutionary step. I did not imagine at the time that this was possible, and this is the main strategic value of the EFTA pillar. Now, EU membership would mean losing the EFTA pillar and the exemptions from the common policies, fishery, agriculture, currency, foreign trade, and so on. Iceland would leave the EFTA Court and ESA and would be bound by European Union law. And even if you were able to negotiate exceptions, they would be interpreted by the Commission and by the Court of Justice of the European Union. Further, advisory opinions are strictly speaking not legally binding. Preliminary rulings of the Court of Justice are fully binding. When I was president of the court, I didn't like the situation so much, but I mean, it's objectively a fact. And ESA is reluctant to bring an infringement action if a Supreme Court, be it of Iceland or of Norway or of Liechtenstein, refuses to implement an advisory opinion. Moreover, no Supreme Court is legally obliged to refer cases to the EFTA court. I always said they should, but they cannot be forced at the end of the day. When the iSafe case started, the EFTA court had a strong position, had developed a strong position over the years, and Icelanders have heavily contributed to that. I will just mention my late friend Thor Williamson, the first Icelandic judge, my friend Þorgeir Örlygsson, who later became Chief Justice of Iceland, who wrote the very important judgment in the Norwegian waterfalls case. In my view, the second most important case of the EFTA court after iSafe. I would mention the Chief Justice, the current Chief Justice Benedikt Bogason, who sat as an ad hoc judge in the Fosen case, in the first Fosen case. And I would mention Skúli Magnússon, who made a brilliant career, started as the registrar of the EFTA court, and then went up the ladder and is now sitting on the Supreme Court of Iceland. As far as academic literature is concerned, I would mention my good friend Stefán Már Stefánsson. On the 28th of January 2014, I will never forget that date because it's also the name of Charles the Great, you know. The EFTA court found in favor of Iceland, holding that EA law did not oblige Iceland in a systemic banking crisis to guarantee the liabilities of a private bank. Do we have the right slide here? No, not yet? Yes. To guarantee the liabilities of a private bank. Now, I cannot speak for my fellow judges, but I have benefited from the fact that my wife had dealt with the concept of moral hazard in her PhD thesis. And we based this judgment on the need to avoid moral hazard. And the Financial Times reported very fairly and very objectively about this judgment and said they did the right thing. Although, at the end of the day, the losers of the case were also the British. And the same with The Guardian. Very fair reporting in The Guardian. The Economist, not so good. But they also misunderstand the referendum. The iSafe case shows that the EFTA pillar can shield a small state in an existential crisis. We didn't decide the case in favor of Iceland because we wanted to do a favor. We decided it on sound legal grounds. But it could well have been that another court would have found another solution. The Commission, for its part, had sought a judgment against Iceland, which was then an accession candidate, and the loss in this case could have meant severe fiscal strain, perhaps even sovereign bankruptcy. And the EFTA court was aware of this. It is legitimate from a methodological standpoint to take into account not only the micro consequences of a ruling, but also the macro consequences of a ruling. And that's what we did in this case. When I prepared this lecture here, I found an interesting article by two Icelanders who apparently teach at the University of Copenhagen with the names of Helgadóttir and Ólafsson. And they focused on the two referenda which had been called for by President Grímsson at the time. And they write, the iSafe referenda transformed a technical dispute over deposit insurance into a question of national sovereignty and resistance to external pressure. And they call these two referenda resistance referenda, and they say they enable domestic actors to fight international constraints and national elites. National elites also. We have here a parallel to Switzerland, which is a direct democracy, and I would like to, to use the expression Switzerland here. Okay, my sixth issue is energy. Iceland has an isolated grid which supplies stable, renewable power. EU accession would not automatically require a submarine interconnector, but over time, energy market integration, climate policy, and solidarity pressure could make permanent refusal harder. My firm has advised the Swiss Parliament on the conclusion of an electricity agreement with the European Union, and we told them they should look to the Norwegian experience here. Norway is the battery of Europe, but even Norway has suffered from the situation in Germany. Interconnectors can transmit not only electricity, but also European price volatility into national electricity markets. In this case, the Norwegian electricity market. And what is particularly fatal here is the failed German Energiewende, which this has an impact on Norway and could probably have an impact on Iceland. I quote here the editorial board of the Wall Street Journal, 29th January 2019. They said, this is the world's dumbest energy policy. After giving up nuclear power, Germany now wants to abandon coal. Point number 7 is now this question, is the European Union today, not 15 years ago, today, an attractive bride or an attractive group? Accession must be judged against today's European Union. And I would say it's not so attractive. Doris and I have been living in Luxembourg, very close to the French border, very close to the German border. Doris is a German citizen, an EU citizen. Our daughter is an EU citizen and a Swiss citizen. And unfortunately, the development has been very, very negative. The traditional paymaster Germany is in deep and long-lasting political and economic crisis. In 2025, 88,000 people left Germany. Not blue-collar workers, academics, doctors, IT specialists, engineers, most of them to Switzerland. And jihadist terror is a daily problem in Germany because politicians and authorities play it down, ignore the causes, and shy away from decisive measures. I cite here the leading Swiss newspaper, Neue Zürcher Zeitung, of 31st July of this year. The second superpower, France, has always been handled with kid gloves by the European Commission. President Giscard d'Estaing said in 2003, not all member states are equal. And the result of this treatment is a horrendous debt economy. A former president of the European Commission, Jean-Claude Juncker, a Luxembourger, was once asked why France always gets special treatment. And he answered, parce que c'est la France, because it's France. He meant it as a joke, but every good joke has a true essence. In the next election in France, the risk is that of a far-right or a far-left president. And I like what the late Czech Foreign Minister Karel Schwarzenberg has said, who was also a Swiss citizen. He said after Brexit, an EU dominated by French centralism and implemented with German thoroughness, mit deutscher Gründlichkeit, fills me with dread. Without the British, the joy of dissent is missing. Third point here, when I speak about attractiveness, is the EU's regulatory reflex. In areas such as digital services, sanctions, artificial intelligence, industrial policy, and freedom of expression, the European Union manages risk through administration, reporting duties, platform obligations, bureaucracy. The Commission increasingly acts as a political executive rather than as a neutral institutional guardian. The traditional role of the Commission was to guard the treaties by applying EU consistently and independently, and that's a huge difference to the EFTA Surveillance Authority. ESA neither has the ambition nor the power to act in this political way. And most importantly is that freedom of expression is protected by the EU Charter, but it is affected by the Digital Services Act and related rules on so-called disinformation and hate speech, which encourage platforms to remove more content than is legally necessary. You remember what happened in July of this year when chat control was pushed through the European Parliament by a pure abuse of procedure. The leadership knew that most parliamentarians were already in holidays and that no majority against this would be possible, so they scheduled it and it went through. Measures against serious crime must remain targeted, precise, and independently controlled. And the other point I want to make here is that a Swiss citizen with the name of Jacques Beau was sanctioned for pro-Russian propaganda without a hearing because he took another view than the Commission on the reasons of the Ukraine war. And this has not only been criticized by conservatives or right-wingers, but for instance, by the social democratic former German Court of the European Union judge Nino Kolnerik and the French professor Alina Miron, who said such measures raise serious questions under EU law, European Human Rights Convention, and international law. And when it comes to technology policy, I do not invoke Donald Trump. I invoke the darling of all Europeans, Barack Obama. European Union often regulates faster than it innovates when it comes to technology. Iceland should distinguish access to the digital single market, which is largely secured through the EEA agreement, from the assumption that EU membership would create domestic technological capacity. Barack Obama said 10 years ago that the EU was using antitrust law and tax law against US innovators to compensate for its technological weakness. And finally, a word on my former sister court, the Court of Justice of the European Union. The German judge of the Federal Constitutional Court has famously said the Court of Justice is freer than any national court. I gave you the latest big example, that was Commission versus Malta, a judgment of the Grand Chamber, where they found that the Maltese investor citizenship scheme was contrary to EU law. Malta had this scheme that if somebody made a major investment, a couple of million, not Icelandic kronas but euros, you could become a citizen. And the Court of Justice, without a legal basis, said the acquisition of union citizenship cannot result from a commercial transaction. That is unlimited interpretation, because deciding on the granting of a country's own citizenship is the core of statehood. So they just took this competence, and nobody, well, if you look at how many passports were given in Malta a year, it was 53 passports. But when the Spaniards or the Germans nationalize hundreds of thousands of people who become European citizens and don't even bring money but are even a burden on your public purse, nobody objects. A very peculiar provision in European Union law is Article 13 of the Treaty on European Union. That provision says the Union shall have an institutional framework which serves its interests, those of its citizens and those of its member states. And the Court of Justice is mentioned here in the same way as the political institutions. And that's, frankly speaking, quite something, to have such a provision in your most important document. And you can imagine what it means if the Swiss would vote yes to this treaty, where the Court of Justice would be the court for Switzerland. I mean, in cases of doubt, the Court of Justice would have to follow this Article 13. And you could not even blame them, because it is written in the law. Now, my last issue concerns now the most practical question for the referendum. What is the real function of this two-stage procedure? That first you vote on the 29th of August, and then you may have another vote if you have voted yes on the 29th of August. And there, given my long experience with European law and with the European institutions and with the way the European Union spreads its message, my conclusion is quite clear. This two-stage procedure is not a neutral fact-finding device. Its purpose is to move the accession decision forward. A yes on the 29th of August would formally only be a mandate to negotiate, but in practice, it would be treated as a decision in principle to join. Politically, not legally, but politically, this could create an irreversible situation on the path toward EU membership. And the technical term for this is path dependence. You know, given my Texas past, I don't say path, I say path. If you vote yes, then a momentum would be created which would make reversal very, very difficult. A later no would then look like a wasted opportunity. EU networks would reinforce that pressure before the second vote. And we all know how EU propaganda works. As a network of institutions, of governments, of media, of NGOs paid by the European Commission, so-called experts that repeat similar pro-integration narratives on and on. The core method is framing. Integration is associated with peace, with democracy, with stability, values, modernity. Skepticism is portrayed as isolationist and backward-looking, and experts are used all the time to make political choices appear like technical necessities, and benefits are stressed while costs and sovereignty issues are minimized. And the result is language of unavoidability. It's Tina. There is no alternative. if you go to Brussels, you look at one of the biggest buildings of the European Commission, and then you have this. They write democracy there. Frankly, if somebody needs to write that in such big letters, something may be not so perfect. I remember very well that in my younger years, I was a professor at the Free University of Berlin. That was the time when the wall was still there. And Doris and I went to East Berlin on a regular basis. And there you saw these kind of slogans. You know, they would write, for the next party congress, we improve our output. All for the victory of the socialism, and so on. Now, it has already started. Former Belgian Prime Minister Guy Verhofstadt is already now urging Iceland to make an unconditional turn towards the EU, which he glorifies as the empire of the good. How modest. And Austrian Foreign Minister Beate Meindl-Reisinger sees world power potential for the European Union and calls for an end of the veto right in foreign and security policy. World power potential, more than 100 years after the end of the Habsburg Empire. Now, let me also take up a sensitive issue. I have been thinking twice whether I should mention it, but I mean, this is an academic lecture. This is not a political speech. Not everybody has understood it, but it's nevertheless the case. The man who led the accession talks after 2019 on behalf of your government is again going to be the chief negotiator today if negotiations are opened. And I'm very sensitive when it comes to this appearance of bias. And this continuity raises a question of prior involvement. In German, Vorbefasstheit. The same architect can make the process look pre-committed to accession than rather genuinely open. The true function of the referendum is not to create the opportunity to find out what is on offer from Brussels. It is about setting a point of no return on the path of EU membership. We have seen historic moments where a point of no return was set. The most famous one is certainly the moment when Julius Caesar crossed the Rubicon, today the Rubicone, between Cesena and Rimini, because once he had crossed the Rubicon, there was no way back. And here we see him with his soldiers, crossing this river. The burden of proof that EU membership would be better lies with those, lies with those who wish to replace the existing EDA model, not with those who wish to preserve it. Doris and I wish the Icelanders that they make the right decision on 29th of August 2026. Thank you very much for your attention.
Thank you. Thank you very much, Carl, for this very frank, very clear, please sit again, lecture. Also, thank you for the courage of dealing with a number of sensitive points, which I think most of us in this hall would hesitate to raise. But let me also share with you that I found inspiring as well as intellectually interesting to see how your European academic culture and personal experience from Switzerland, Germany, France, Luxembourg, and others was kind of interwoven into your presentation. It's often said in the debate here in Iceland, we have to be European. Dr. Karl Baudenbacher demonstrated very well in his lecture what a European intellectual really looks like. And on a kind of odd Icelandic note, I think you are the only person in the world who could draw Jón Baldvin, Guðni Ágústsson, and Guðlaugur Þór to sit together on the first row. I apologize to my three young people for having personalized this occasion in this way, but also I couldn't help reflecting when you were saying that an agreement cannot consist solely of exceptions to every area. That long time ago, when Jón Baldvin and I were ministers in the same government, and Guðni was a young MP who was trying to feel his way around the parliamentary building, President Mitterrand came to Iceland. He was then the head of the European Union. This was the beginning of the EEA negotiations. And there was a meeting in the ministerial house, the old ministerial house. Jón Baldvin can correct me if it's not correct. And at that meeting, the Prime Minister and the Foreign Minister, Jón Baldvin, listed all kinds of exceptions that Icelanders might need in this potential negotiations. Until Mitterrand kind of leaned back and said, gentlemen, an agreement cannot consist entirely of exceptions. So you reminded me of Mitterrand in your talk. But before I open the floor to questions, if I may ask you to perhaps summarize very briefly to a layman, what is the essential distinction between being under the European Court, if Iceland joins the European Union, as compared to being under the existing structure of our own courts, as well as the legal arrangement with the EEA agreement? For most Icelanders, this is a very complicated issue, but can you perhaps summarize in a clear, short statement, what is the essential difference?
Yes. Thank you very much. I mean, first of all, it's a matter of size. The Court of Justice of the European Union consists of 27 judges now. And if you look at their architecture, if you look at the three golden towers where they are sitting with virtually now 3,000 employees altogether, and the golden courtroom, which has been described once by a judge of theirs, it looks like an Arabic hotel. You see their sense of importance and their sense of, they are conscious of their power. Whereas the EFTA court go to their premises, they are somewhere in the basement, and thanks to Skúli Magnússon, they have an own courtroom. Before that, they didn't even have a courtroom. We had to hold the hearings in a hotel. So, I mean, already this gives you a sense of the difference in power. And then the Court of Justice would use, as a matter of principle, a dynamic method of interpretation. I'm not saying that the EFTA Court has not also used this method occasionally, but the EFTA Court never had as much power as the ECJ. First of all, because no Supreme Court is legally obliged to refer a case, or at least this can be only, attacked by difficulty, a violation of the duty of loyalty. And secondly, a Supreme Court cannot even be forced to follow the EFTA Court. Now, Iceland was quite compliant over these 32 years, but the Norwegians used this with system. Whenever a ruling of the EFTA Court didn't please the state attorney in Oslo, the state attorney said to the national judges, this is unconvincing, you shouldn't follow. And since many of the people working for the Norwegian courts, are former bureaucrats, they had it in their genes, more or less. And all this would be gone if you would join the European Union, quite clearly. I think that the difference is even bigger between the Commission and the EFTA Surveillance Authority. ESA, as I said, has neither the ambition nor the means to be a real political actor. ESA is a watchdog and an implementer, whereas the Commission was, until 15 years ago or so, the guardian of the treaty. But already Juncker said the day he became president, I want to have a political commission. And then von der Leyen said, I want to have a geopolitical commission. And it's quite clear that the more political you are, the less you can be, calculated. The less people can rely that everything is going to go according to the law. And so we have the situation, that Giscard said, not every member state is equal. He even spelled it out. Can you believe this kind of arrogance that you spell this out?
Well, so, we have a number of questions here. I will take them in the order they raised their hand. You have the microphone here. Let's stick to the girl on the third row. Yeah. And then we go up there to the balcony and then Jon Balvin here. Yeah. If you can introduce yourself.
Yes, hi, Carl. My name is Margaret Augusta and I'm a lawyer specialized in EU law. So I'm familiar with all of your working, and Cecile Brokeland, professor from Lund University, probably says hi to you because, we can take that later on. Regarding the constitutional rights of a member state, I was wondering, because it's very interesting, the Meloni judgment and Simmental is a landmark cases regarding, if you could describe that, it's a, how do you say it, regarding from Costa versus Enel, where it's a landmark case and says, okay, human rights are less protected because if a common policy within EU says something else, then the human rights can get lower even though the constitution of a member state says so. So I was wondering if we can also...
Okay, thank you very much for your question. Can you bring the microphone to... Okay, got
and
it.
I'm also the work for Farmers Association, so this was just...
No, I'm not here to lecture on some details of judgments. I'm sorry, but I don't think that most people are interested.
Can you get the microphone a bit closer?
Yes, yes. What I'm saying is that, at the end of the day, the Court of Justice has become so powerful. It's the second most powerful court in the world after the US Supreme Court. It cannot be controlled at the end of the day. If you look at how the court is constituted, it consists not mainly of lawyers, of judges from the member states, or of practicing attorneys from the member states, not even of normal professors. A high percentage of the judges are former secretaries of state, national bureaucrats. That is an important issue. These people have been socialized in a political way and not in a legal way, at least not only or primarily in a legal way. On top of that, there are revolving doors between the European Commission and the Court of Justice. And since the Court of Justice doesn't know the system of dissenting opinions, they vote in secret. Nobody can know how an individual judge has voted. That's totally different from the Nordic traditions. And that gives the court a lot of power because individual judges cannot be held accountable for how they have voted. On top of that, the language of the court is French, which means that every judge must have at least one French speaker in his or her cabinet. And language also transports thinking. That means the French thinking goes directly into the judgments of the Court of Justice. If you look at the reasoning of the judgments, it's often less detailed than what the EFTA Court does, because the EFTA Court is not so powerful. They have to give reasons. They have to convince people in the member states. ECJ can say, that's the way it is, and nobody knows how it went. I was always in favor of dissenting opinions, but the EFTA Court on this point has had to take over the system from the Court of Justice. But I mean, this is the main difference. And when it comes to the Commission, it's obvious, you know, ESA, with this number of 70 people or so, they can never start political initiatives in the way the Commission would start them.
Thank you very much. Very clear. Yeah.
Ég heiti Magnús Hreggviðsson, and I've been self-employed for over 50 years, so I'm old enough to know that I know very little now. But I have a practical question if you could answer, and thank you for your excellent explanation about the possibilities of our going into EU. European Union wants to own and rule over the fisheries. Icelanders want to rule and own the fisheries in Iceland. But the main person that is making or supervising the deal making between Iceland and EU says, smiling, there is no problem because European Union wants to own and rule over fisheries in Iceland, and that Icelanders can do too. So we find a progressive solution to this. But I've been a businessman over 50 years. I don't know what a progressive solution could be in a legal sense. Thank you.
Neither do I.
Okay, Jón.
I feel certainly a certain need to introduce myself to this eminent but unusual audience. My name is Hannibalsson, and I was the Foreign Minister of Iceland who had the honor to be politically in charge of our negotiations with the European Union on the EEA. It should be mentioned, first of all, I would like to thank you for your eloquent eulogy of the EEA agreement, which now is usually acclaimed by everybody, but was very controversial at the time, among others because my allies in the government, such as our former president, turned against it at the time in 91, in the elections 91. Now, apart from this, I would like to turn your attention a little bit to the future. I thank you for your lecture, and I am here to pay my respect to your achievements in the past, which Icelanders should not forget. But when we look a little bit ahead, out from the match of today, we notice a trend, a massive trend of transfer of power from nation states to regional, to superpowers, to regional alliances, to multinational capitalist organizations. The European Union, the founders of the European Union said, let us aim at a closer and closer union. The biggest steps so far have been the inner market and then the common monetary policy. But in this sense, the European Union is only a halfway house. What about fiscal policy and state management? When you look ahead, do you envisage a European Union which will move in the direction of the United States to become a union of non-sovereign states? Or do you envision a development towards independent states in a practical alliance within some restricted fields? I think it would be very beneficial for us to hear your view on this. Thank you.
Thank you very much, Mr. Hannibalsson. I know very well who you are. Let me put it that way. I was always in favor of Swiss European Union membership. And then I became a judge on the EFTA court, not on behalf of Switzerland. I was the judge on behalf of the Principality of Liechtenstein. And I was sitting on the EFTA court for so many years, and I witnessed how the Commission, which was our partner, so to speak, in the court proceedings, because they would plead in every case, how they developed. And it didn't get better. It got more political and more political and more inconsistent. You had the impression that from one case to the other, the Commission didn't have a clear doctrine anymore. A lot depended on who was representing the Commission, and there was no clear leadership in the legal service anymore. You saw new directors general in the legal service, political appointees, without a real sound, academic background. And so my feelings have gotten more mixed and more mixed. And in the last years, since Madame von der Leyen is presiding over the Commission, I have become rather pessimistic. The European Union has tried to downplay what Brexit effectively means. Because first of all, they wanted to make the life of the British as difficult as possible. And then they said, oh, you see, they made a mistake. Everything is going badly. And in fact, the British have blown Brexit to a large extent. I can tell because after my time on the EFTA court, when I joined this London law firm, I advised both houses of the British Parliament over 2 years. And we always were trying to convince them, to go together with EFTA. And they didn't do that. At the end of the day, they left the single market, but it went the way it went. I am rather pessimistic, with the Brexit, it's not only that the United Kingdom has left, but the link to the Anglo-Saxon world is no more there. And if you look at, the most important distinction of comparative law is the distinction between civil law, French and German and Italian and Spanish and Latin America and so on, and common law. And common law is England and then America, New Zealand, Australia, South Africa, and so on. And that the whole approach of thinking of the common law is no more present in the European Court of Justice or in the Commission. Only the Irish are still common law, but they are not powerful. The British have left. I mean, they don't admit this loss. And I think this is devastating. I met a Swiss lawyer practicing in China last week, and he told me that when it comes to negotiations with the Commission, you can feel the difference, that French thinking is becoming more and more important, and the old British thinking is no more there. And I think in the long run, that's not a good development. And all those who have now said, well, it's 10 years since Brexit occurred, and it's no success, and so on, they will come back. I don't think they will come back. And I think that European Union, unfortunately, was a great project and has developed fairly well for a long time, but they made too many mistakes. Enlargement was way too fast. The single currency shouldn't have introduced. I mean, this is a weak currency. I'm Swiss. I know what it means. If you compare that to the Swiss franc, they lost, in these years, they lost, I don't know, 65% of the value. That's not an attractive solution.
Well, thank you very much. Since I took 3 questions from this side of the hall, I think it's only fair. Yes, there's one there. If you can bring the microphone. If there's one more on this side of the hall before I go back to this one. But let me also say, although it's probably impossible to get that point across, given the nature of the debate here in Iceland, but what you just said about the fundamental intellectual, philosophical, legal distinction between the 2 legal systems, which you so clearly described, is a fundamental part of the choice we have to make at the end of this month. Because like the British, the Canadians, the Americans, the New Zealanders, and others, our legal tradition is a part of that, as the Nordic legal tradition has been. But as you so eloquently described, we would have to transfer not only the authority, but the whole legal thinking and the philosophical legal structure of our society over to a completely different intellectual tradition, which has been institutionalized by the French and the Italian and the Spanish and the German states for a number of centuries. So thank you very much for bringing this point into the debate, because I think this is the first time that this fundamental distinction has been mentioned within the framework of the Icelandic discussion. Yes, please.
Yes, thank you, Dr. Baudenbacher, for a great lecture. My name is Njáll Trausti Friðbertsson. I'm MP here at Alþingi for Independence Party. Just to expand a little bit how you ended your last speech about the expanding of the EU and what we can see in the waiting room at the moment. Actually, I think is the part that hasn't been discussed in Iceland this summer is the waiting room and the countries, Balkans, and around the Black Sea, what we're going to see in the future concerning this, and how that will evolve maybe in the next 10, 15, 20 years. When we think about all the treaties, the Paris Treaty, then we go to Rome and all those treaties, Maastricht, and then Lisbon Treaty, as our former president Grímsson was talking about the Lisbon Treaty, how things will evolve for small countries in the EU in the next decades. And I think that's a critical question, and actually nobody has talked about it this summer. Thank you.
Yes. Well, you know, I don't remember who said prognosis are difficult, in particular if they are about the future. Very difficult to say. I think that the European Union has made the last big enlargement round too fast. I have seen how this went with the judges. The judges first came to the European Court of Human Rights because these countries joined the Council of Europe. And then after a number of years, they became members of the European Union. And then many of these judges from Strasbourg moved to Luxembourg, not because they were specialists in economic law or in business law, but because in Strasbourg they didn't have an official car, they didn't have a driver, and they didn't have a pension scheme. So that was not a very convincing development. And now these Western Balkan states are in the waiting room. You are not in the waiting room, are you? You have never been in the waiting room. I find it strange that you are now put into the same package, that EU politicians say, well, then we have North Macedonia and we have Iceland and they could join together and stuff like that. I think this is kind of artificial because you belong to a different world. You were as lucky as my country was. We never lived under communism. We have a different past. And why should we then just one day be in the same bracket? What's going to be the future of the European Union, I don't dare to predict. But I'm sad, you know. I lived in Germany. I was a professor in Germany. I had a very good time. I have a German wife. And I'm sad to see how Germany has gone down in the last, you know, well, after Kohl, basically it started. After Kohl it started, and it was all camouflaged by the press. When the press said, well, the greatest leader is Angela Merkel, and she is the leader of the free world, and on the other side of the Atlantic, we only have crooks, and this kind of stuff. And in truth, Germany, you know, declined so much. And now we had then Mr. Scholz, who came to power, and now we have the current German Chancellor, whom I had the honor to meet a couple of times in my younger life. And if Germany doesn't function, who should pay at the end of the day? The Germans are running out of gas, I mean money. And France, look at the debt of France. The Brits are gone. I'm convinced the Brits will find their way again because the structures are in a way stronger. It's an old democracy like Switzerland. And it's in a way, it's absurd that Switzerland and the United Kingdom should accept the Court of Justice of the European Union as the sole interpreter. I mean, if you look at historic development, it's the most absurd thing you can imagine.
So, are there more questions from this? Yes, there's one here on the balcony. Yes, if you can bring the microphone up there. I'm trying to have a spatial equality here between the different parts of the hall. And if there are one or two questions in this side of the hall or on the back, then I will take those before we finish. Yes, please.
Well, thank you, Dr. Karl, for your excellent lecture. My name is Jon Gunnar. I'm actually a board member of a couple of companies, but in my prior capacity, I've been a government bureaucrat, investment banker, lecturer on law and economics. I've been around, let's say. I just want to ask you a question about how would you envision the negotiations proceeding, assuming that there will be a yes vote and we will actually continue negotiations with the EU. So will the EU present a draft to us from which they will want to negotiate? Will those drafts be somehow based on a fresh approach by the EU towards Iceland? Will it be based on drafts that have been proved on chapters that have already been opened? You mentioned in your lecture that we are actually voting on the EU as it is currently, not how it was 15 years ago. But are there any way that we can negotiate some kind of standstill provisions whereby we say, okay, you're not going to impose or take away veto power, you're not going to be changing the provisions regarding the oversight or the responsibility for common defense policy and so forth and so on. So that's my question.
Yes, thank you. You know, I'm a judge, or I was a judge, and I've never been a negotiator, so I don't know exactly how this works. What I know is that, I mean, these are not real negotiations. You cannot compare that to businesses, you know, who come from the same starting point. The starting point is that there is the acquis, the so-called acquis of the European Union. That is their whole body of law. And the new member state must, as a matter of principle, take over this body of law. And then what the EU would grant, or has granted in many cases, is transitional periods, so that you get the chance to adapt to the new system. But permanent exceptions, they deeply dislike in the European Union. And as I said, even if you would get an exception for fisheries, you couldn't come the next day and say, oh, also in agriculture, we have a peculiar situation up here, we are far away and so on. And it is recognized in modern comparative law that geography should be taken into account. You can plead that, but they will say, well, you know, as my old late friend Williamson used to say, Thor Williamson, yes, I can hear what you say. You know, that means you can say it, but I don't care about it. And so, I mean, probably one exception, but this exception would then also be under the interpretation of the Commission and of the Court of Justice. And who knows what's going to be the situation in 10 years? You know, whether the Spaniards would then say, or the Danes would say, well, we dislike this fishery exception here. We want to have it defined in a more restrictive way. You know, this is then the art of interpretation. You know, and lawyers are full of fantasy when it comes to interpretation. And a lot of things are possible, and then even if a text is clear, there may be a provision in the preamble somewhere, or they invoke the spirit, or something like that. They have done that in the past. Well, we also did such things when I was on the EFTA court. I admit that. You know, that's part of the judicial business.
Well, let's take one more question. Yes, please.
Yes, thank you. Thank you very much for a very inspirational talk, Mr. Dr. Baudenbacher. My name is Guðmundur Ásgeirsson. I have studied a little European law. I have visited, during my time at the university, I did visit the EU institutions in Brussels on a school tour. But I am also the chairman of a small group called the Coalition for Sovereignty in Iceland. And our biggest and proudest achievement is an online petition we held in the year 2011 in opposition of state guarantee for bank liabilities. Which thankfully resulted in the highly esteemed President, Mr. Ólafur Ragnar Grímsson, to direct the so-called ESB law into a referendum, where we actually won the election without being a running candidate, which is quite unique. And as you are familiar with, the ESB dispute later was brought before the EFTA court during your presidency there, Mr. Baudenbacher. And as you can imagine, I was very happy with the judgment in favor of Iceland in 2013. It is my understanding that a year later, in 2014, the EU amended their directive on deposit insurance to, regardless of the judgment, impose state guarantee for deposit insurance on its member states. But this new directive has not been incorporated into the EEA agreement, primarily, as I understand it, because of Iceland using its veto power in the EEA committee. Importantly, this referendum in 2011 was binding, not advisory, as the one will be on August 29 this year. Under EU law, directives have what is called a direct legal effect domestically in member states. So if Iceland were to join EU, if my understanding is correct, this new directive imposing state guarantee on bank deposit insurance would immediately take legal effect in Iceland.
Is that the question? Or?
My question is, and I'm sorry for this long introduction to the question, my question is, how can this be reconciled with the no we gave in a binding way in 2011 to state guarantee for deposit insurance? Or is it fair to say that the no in 2011 is today and has since 2014 been equal to a no to EU membership? Thank you.
Yes, well, thank you. You know more than I do on this, obviously. I was not aware of this directive in the European Union law, but if it is the way you describe it, and I don't doubt it, then the situation would change. If you were to join the European Union, then European Union law would directly apply. That is quite clear. We, at the time, gave interpretation to the directive as it stood. And even at that time, a lot of observers said, had this case ended up before the Court of Justice of the European Union, Iceland would have lost. And some famous authors even said the EFTA court has made a blunder. The EFTA court should have ruled otherwise. I was invited after this judgment to the annual gathering of all the deposit guarantee schemes of the world, which took place in Rome in a fabulous palazzo of the Banca d'Italia. And I gave the keynote speech there and spoke about the ISF judgment. And then most people didn't dare to ask a question. But one guy said, yes, you said you couldn't find a legal basis in the directive for your judgment. In this case, you should have assumed that there's a gap in the law and should have filled it and should have sentenced Iceland. And I said, are you serious? Are you kidding me? Do you say that it is for a European court to find a lacuna in such a case, which is about life and death of an economy, and to rule against a member state? Nobody else agreed with him, but we found it the way we found. But if it would be like, as you say, then direct effect of EU law is out of the question. That's quite clear. That's like primacy. You know, all this Protocol 35 business, which has played such a big role in Iceland, this would be over. All this would be over.
Well, thank you very much for sharing your thoughts with us here today. I thank all of you for being attentive listener, also for the stimulating questions that have been put to you. I find it quite remarkable that we gather here in this old hall and we have this display of European intellectual traditions and German and French and Anglo-Saxon legal scholarship put into the framework of reaching conclusions on some of these key issues. I think it's the first time in this extensive debate in our country that we have witnessed how this is being, all these different questions and issues are being put within the framework of the diverse European intellectual traditions. In that sense, I think your presence here and your talk and how you have answered the questions has been an intellectual feast, apart from the political message that you have carried. So since this started out as a university exercise, I want to thank you for this intellectual feast that you have presented here in this hall. And having been for years, even decades, at various lectures, not very far from here, in the area of the campus, I can honestly tell you that very few of them, if any, have matched this intellectual display that you have put on here today. So thank you very much for that. And this, of course, is being sent out on the internet, and it will continue to exist on the internet. And for those of you who don't understand English to the extent that some others do, I think I'm clear that there will be, in due course, maybe within a day or two, Icelandic subtitles on the internet, so anyone can be able to understand what you say. Although I don't envy the translators having to translate correctly the intellectual fireworks that you have put on here today, but I'm sure they will succeed. For those who want to continue at this intellectual dinner table, there is this booklet written by Carl and Laura Baudenbacher, which will be sold out here in the corridor and will be available elsewhere. To continue this discussion and the gathering of information. But let me conclude this by thanking you for the friendship you have displayed to Iceland. Not only did you play a historic role in our modern history, more than any other foreign lawyer, as I said before, but you have continued to visit us. You have mentioned in your talk many distinguished Icelandic legal scholars, which demonstrates that you have been an integral part of the most extensive judicial dialogue in our country. So you arrive in these states not only with your European, German, French, and Swiss background, but also for your long-standing discussions with some of the preeminent legal minds of our country. So thank you very much for that. Thank you also to both of you for having come to Iceland. And with that, I want to ask all of you to join me in a strong demonstration of thanks to Dr. Carl Baudenbacher for having traveled to Iceland and having had the energy, the courage, and the wisdom to share his insight with us here today and through the internet with the entire Icelandic nation. Thank you very much.